Welcome to today's session. My name is Ingrid Konya, an associate at Konya Company Advocates, and with me is...
Hello, my name is Mukami, an associate advocate at Konya Company Advocates. We are located at the Sandbox in Kilimani along Champion Avenue. And on today's session, we will be discussing on estate planning and specifically on the wills. And so we hope you enjoy this session.
So Ashley, I know most times we hear about wills and estate planning when these big billionaires dies, when we hear about the Matibas and the Kirubis, and that's when we get to hear about wills and what happens. So maybe what is estate planning?
So estate planning is basically you deciding and designating what will happen to your assets and what will happen to your liabilities in case you die or in case you get incapacitated, you get an accident and you have a stroke. So if you estate plan in advance when you're alive, this will help reduce the nitty-gritties that goes on after you die in regards to your estate, in regards to how your family will be taken care of, how your business will be taken care of. So that's basically what estate planning is.
Is there a particular age where it's recommended, or is there a particular age when I should start estate planning? Because most times when you're young, maybe you don't have not a lot of assets. You're thinking, I don't need to do this right now. Maybe I should do it when I'm 60 or 50s or 70s. Is there a particular age when I should start considering doing estate planning?
The valid age is 18 years. So from once you turn 18, you need to start thinking about how you'll start planning for your estate. You can even plan who will take care of your mobile phone, or you will have your mobile phone. That's an asset. So you can even plan for that and say, my mobile phone will go to this person, my bank account will go to this person. So you don't really have to have land, big cars, big houses, whatever asset you have. Shares is also an asset. So once you estate plan, you're good to go in case you die or you get incapacitated. But come to think of it, we have 4 ways to estate plan in Kenya. The first one will be the wills that we'll be talking about today, where basically you just give your wishes on what will happen in case you pass on. And the other one is a trust. We have the living trust, where you'll say, you're my son, I don't trust you with money. So once you turn 25, or once you turn 30, this is what you get. That's called a living trust.
Okay.
And then now we have the trust that comes in after you die. So that's the third thing. The fourth thing,
I think we have power of attorneys.
Yes, that's true. The power of attorneys, where you designate what happens while you're alive, that is, or maybe when you're incapacitated, you designate what will happen to your properties or who will handle your properties. Most of the time they're called signees, and you who's giving out the authority or the power to take care of the properties, you're the signer. But the thing about power of attorneys is once you die, it's revoked.
All right.
So again, I think, come to think of it, I will be the best.
The best bet. And we've said it's never too late or it's never too early to start doing your estate planning.
Correct.
So maybe just to start off, what's a will? Maybe there's someone out there who doesn't even know what a will is.
So a will is a document that entails your last wishes and testaments, how you want your properties to be distributed, who you want your children to be taken care of by whom, your liabilities, how you want to be taken care of. And basically just list your last wish and testaments.
Okay. So maybe what are some of the advantages of me putting into place a will?
Vis-a-vis not having one.
Yeah, vis-a-vis not having one.
Okay. The first one is you'll have control over who will get what. Because if you die without a will, only your immediate family members, your beneficiaries, will be entitled to have something from the will. So imagine you've been taking care of orphans or children outside marriage, and they're not in the will. That means that it's going to be very difficult to differentiate the two. So if you have a will, you'll be able to put everyone, you'll be able to have control over who gets what, and basically you'll also be able to have control over who is going to administer the property. By administering the property is who's going to collect this information of the properties you have, and who is going to now actually distribute it. Basically, you need someone you trust, who's going to be called an executor. So at least when you write a will, that will be in place.
So I know in our last video we talked about presumption of marriage. So can I put what do I call them?
Children born out of
Born out of or maybe we talked about cohabitation and a presumption of marriage. So what if I've been living with my spouse but we're not legally married under any of the regimes of marriage? Can I still put them under the will?
Yes, you can. Actually, you're allowed to put anyone that you're actually contributing to, that you're actually taking care of when you're alive.
Okay.
Be it children that you have outside marriage, within marriage, whether it's cohabitation, you can put basically anyone.
So you can even put even my friends.
Of course.
There's no limitation.
Actually, even the beauty about having a will is you can even gift out jewelry. You can even gift out art.
I think I've seen. Is that possible in Kenya?
But I'm sure. But let's see, if you bequeath your property to someone, people you've been taking care of, and then you leave out people you leave out people you've been taking care of from the will, they have a right to challenge that. And you can show the court. You guys, you see, you were being taken care of for this person, but he left us out in the will. But priority is for the people who have been listed in the will.
Okay. So now, so I've made up my mind. I want to now put in place a will. So as I'm doing this will, what are some of the considerations that I take into place?
So first things first, you need to know who your executor is. Your executor is a person who will take care of your property, will make sure your property will be distributed as you want. So the first thing is to appoint your executor. Mostly will be your spouse or parent or a sibling.
So someone you trust.
Basically someone you trust. And then number 2, identify who your beneficiaries are. Your children, your spouse, your friends, your siblings, your parents. And then have a list of your assets and the list of your liabilities. So for the assets, it's both assets that are in your name, and both assets that you are intending to buy. Maybe you have a contract, a sale agreement in place, but the property has not been transferred to your name. So you need to list down that. And then the liabilities. How do you want the liabilities to be taken care of? Do you have a loan? How do you want it to be taken care of? And then the beauty about a will is you can, what's the word? You can actually change it at any time.
Okay.
So you've prepared a will, it's paid off the liability. You can come and say, you can put in a codicil and say that I've taken care of this liability, so you remove it. And then now, even if you buy property, you can equally include it.
So same thing, like for example, if I have 2 children today, in another 3 years, maybe add another child. Correct. I can always amend my will.
You can always amend.
So if someone annoys me, can I also just equally remove them?
You will remove.
Okay.
So the will is flexible. Provided you're alive, you can change in whatever way you want.
So that's one of the, I'm guessing, importance or it's the flexibility
of having a will in place.
Okay. Other than through a will, maybe I have various types of assets. In what other ways can my beneficiaries, or rather in what other ways can these assets transfer to my beneficiaries? So for example, maybe I have a policy, an insurance policy.
Most of the time when you have an insurance policy, you can nominate who will get these funds in case you die.
Okay.
So that it's called transmission by way of nomination, transmission of property by way of nomination. So once you nominate someone in your policy, or you're doing an investment and you nominated someone to receive these funds upon death, it will directly go to that person and you really don't have to go to court.
Okay.
Yeah. And then maybe the other is survivorship. So you jointly own property with someone, you jointly own property with your spouse. By operation of law, that means then once you pass on, your interest in that property automatically goes to the surviving owner.
Okay.
Owner.
Okay.
And then the other one is the gift in contemplation of death. And for example, you have a car and then you've given out your keys to someone, and that person has been using that car for a long time. So in case you die, that gift passes on to that person. It does, and the gift is actually cannot be included in the will.
Okay.
Yeah, so it automatically devolves to that person that
Okay.
you've been gifting.
So I've taken account all the assets I have, the liabilities, my beneficiaries, and what I want to give to whom. So now I want to sit and now do this will. So what are some of the valid elements that will make it valid?
So you imagine you've done all that, you have created your will, and then all of a sudden you die, and then the will is invalidated by court because you've not done one or two things. So it's very important, first of all, let your will be drafted by a lawyer, because he or she will know the validity of how to make this will valid. So some of the things you need to know is, number one, you need to be of age. That means you need to have attained the age of 18 and above to prepare this will. As a child, you can prepare a will, but once you achieve the age of 18, you have to cement it and say, this is indeed my will.
Okay.
And then the second one, you have to be of sound mind. That means you have to be sane. Or if someone is not of sound mind, but in the lucid moments, you're able to know who your beneficiaries are, who your executor is, your liabilities, your assets, and who will take care of your children as if they're minors, then you can actually write out.
So you understand what you're doing, basically.
You have to understand what you're doing. And then the third one will be signing of the will. A will must be signed. If it's unsigned, it's not valid. You can't use it. And then that signature has to be witnessed by two adult people. And if a beneficiary is one of the witnesses who is appending the signature, then that signature of the witness has to be witnessed by someone else.
Okay.
So basically, it's easier to just have two witnesses who are not beneficiaries, and your will be valid.
So of importance, just go through an advocate. Don't go through ChatGPT. To not help you. Okay.
Maybe it will. Actually, you can do your will online.
Oh my God.
You have to remember these issues, but it's good.
Okay. So what happens if maybe I'm a child and maybe my parent has passed away, or I'm a spouse, they had left a will, but they've not included me in the will. They haven't given me anything, and I'm feeling I want to get something. Do I have any recourse?
Yes. If he or she, your parent or your spouse, is taking care of you during his lifetime, you can actually approach the courts. We've spoken about this in our article on our website, koi.co.ke, in depth, and we hope you'll have a good.
So go check it out.
Yeah, go check it out.
Thank you for joining us in today's video. If you liked our content, please feel free to share, like, and subscribe. For any more information, or if you have any questions, please do feel free to reach out to us through our email or our contacts, which will be provided down below. Please make sure to join us for our next video, where we'll be talking about intestate succession.